So good afternoon and welcome to our webinar on the Legal Ombudsman rule changes with Paul Wightman of DG Legal. For those of you who haven't joined our webinars before, my name is Sammy and I'm the Business Development Assistant at DG Legal. So the slides from today's presentation will be sent over tomorrow and a recording of the webinar will be made available. So if we do run over and you need to leave, you will be able to watch the rest at another time. We are in webinar mode, so we can't see or hear any of you, so please use the Q&A function for your speakers to answer your questions. So Paul is a qualified barrister who graduated from Birmingham University and was called to the bar in 1994. He has spent almost 20 years working for the Law Society of England and Wales. In 2018, Paul took up the role of a Level 2 Ombudsman at the Legal Ombudsman to make final decisions on the most complex complaints made against legal service providers in England and Wales. He became the technical lead on conveyancing complaints and has delivered training and written guidance for the Ombudsman in this area. So over to you, Paul.
Well, good afternoon, everybody, and thanks very much for joining us for this session on the Legal Ombudsman rule changes, what solicitors need to know. And thank you, Sammy, for the So we've scheduled this this session today on the 30th of March with the new scheme rules coming into play this Saturday on the 1st of April. As Sammy said, I worked for the Legal Ombudsman from 2018 onwards, and I have been watching the proposed changes and the consultation with great interest, both as a former ombudsman, but also as a consultant now helping firms deal with service complaints from the other side of the floor. So the agenda that we'll be running through today is basically, I wanted to give you a little bit of a background to the scheme rule changes. There's been a lot of publicity setting out exactly what the changes are, but I think it would be quite useful to have a little bit of information for solicitors just to put the scheme rule changes into some form of context. We'll then have a little bit more of a look in detail at precisely what the changes are to the time limits. The time limit changes are probably the most significant aspect of the changes and how they will impact on the scheme moving forwards. One thing that will affect all firms, and solicitors certainly will need to know, is about the new signposting requirements. Whether or not you generate any legal ombudsman complaints. For those not generating any complaints, the changes to the scheme rules will have minimal impact. But one aspect that it is important that you know is the requirements and the changes to your signposting that will need to be made as of this Saturday. So the timing's great to collide with year end, but there we go. We'll at least today be able to run through and give you a little bit more information on that to make sure that you're fully aware of the requirements in that area. We'll then have a little look at the additional steps that you may wish to consider taking to inform existing clients of the changes. Before then looking at the impact of the changes to the operation of the scheme. So how will it impact any solicitors who have complaints that escalate to the Legal Ombudsman? We'll be looking at the extension of the powers to dismiss or discontinue under Rule 5.7. We'll be looking at the limitation on time periods for the right to challenge an investigation, and also the loss of automatic rights to an ombudsman final decision. So there will be the opportunity to ask questions. Sammy will pick those up if you want to leave them in the question and answer slot. As Sammy said, we would not be actually picking up the, we can't see or hear you. So if you could put them in the slot, we'll pick them up on the end. So the learning objectives following on from that agenda, really, by the end of this, I'd like everybody who's joined here today to have a very clear idea what the new time limits mean, how they interact with the Rule 4A and B requirement to raise the complaint with the Ombudsman within 6 months, and how these changes interact. I'd like everybody to understand what the signpost requirements are moving forward now from this Saturday, the 1st of April 2023. Have a more informed view of what additional steps your firm may wish to take in regards to informing existing clients who will have been informed, probably, and under your previous signposting of the previous limits, what steps you may wish to consider. The opportunities for anybody dealing with a complaint to actually use the extended powers of the Ombudsman to dismiss or discontinue a complaint, and also to have a better awareness of any procedural risk from these changes when responding to a legal Ombudsman complaint. Those risks really fall into the two categories of the removal of the right to the Ombudsman final decision. That's always been an automatic right up to date. And also the need to make a challenge under Rule 5.4 at the earliest opportunity. So I said that I initially thought it would be useful just to go into a little bit of the context of these changes. Sammy explained that I'd worked when I joined the what was then the Office for the Supervision of Solicitors in 1999. It was a last-minute application, and I originally joined for 1 year, and I always remember on the way up to the interview for that job, reading the paper, and the then Law Society chairman, because the Legal Complaint Service or the Law Society actually conducted the predecessor scheme, which when I joined was the Office for the Supervision of Solicitors. And I remember reading, as I was coming up for my first interview, the then Law Society president criticising, and I think it was Martin Mears at the time, was criticising the performance of the then complaint scheme operated by the Law Society, and the expansion that was taking place. I think we were described as a collection of painters and decorators by Martin Mears at the time, which felt a little bit odd reading that coming up for an interview for the role. But the background to this, obviously, and I suppose the point I was making was that the predecessor scheme, the then Legal Complaint Service, when it was introduced, was actually itself deemed unsatisfactory. The Legal Ombudsman Service was set up under the 2007 Legal Services Act and introduced and came into force in October 2010. Itself, it was therefore, and I remember at the time I was the chair of the Law Society's trade union, and I was involved in the negotiations. It was I met the minister at the time, Bridget Prentice, at the Justice Department, who said the spirit of 2P will be applied, and the idea was that many of the staff for the predecessor scheme would move over. But in actual fact, there were strong political pressures at the time for it to be seen to be a new start. The initial chief executive, Adam Sanson, was very keen to introduce a new set of scheme rules and for it to be seen by the public and the consumer bodies as a complete break with the past. I think only about half a dozen people from the one scheme moved over. So the Legal Services Act gave the Office for Legal Complaints, who are the oversight body for the Ombudsman, the powers to make a set of scheme rules, and they were doing so really with a clean slate, but within the restrictions of the Act. There was a lot of pressure at the time to, when drafting these scheme rules, one, to do it quite quickly because it was coming into force in October 2010. But there was also, I suppose, a degree of pressure from the consumer bodies that it was seen to be more consumer friendly. The scheme rules were designed to help consumers in more situations than the predecessor body. For example, the predecessor Legal Complaint Service would shy away from any complaints that had an element of negligence about them. Not the case with the new Ombudsman scheme. the Ombudsman scheme rules went into such areas. It wouldn't make a finding of negligence, but it would potentially go into consider issues of service that would form the basis of a negligence complaint and decide, on the basis of the evidence, whether or not the service had been reasonable. It also would go much further than the predecessor body in terms of allowing complaints from beneficiaries, because beforehand complaints were very limited to client complaints, residual beneficiaries where the firm were the executor would potentially, residual beneficiaries could potentially raise issues of relating to delay or where they hadn't received proper cost information. But the Legal Ombudsman scheme was certainly expanding the levels of protection. Now, in recent years, anybody who's been looking at the legal services the Ombudsman and the performance will know that there have been well publicised criticisms of the LeO scheme. For somebody who was an employee at the Legal Ombudsman and an employee at the predecessor scheme, a certain feeling of deja vu there. There's been a well publicised criticism of the large front end backlog and the delays that this has caused for scheme users. When I was initially recruited to the predecessor scheme in 1999, the previous chief executive of that scheme had just been sacked because he'd come up with the idea of sending any service complaints back to the complainant and saying, contact us again in a year's time if your problem hasn't been resolved by then. That wasn't well received, but it was indicative of the fact there was at that stage about a 30,000 backlog. So a real feeling of deja vu, actually, with some of the recently reported criticisms of the Legal Ombudsman scheme. Clearly an issue that people are raising, concerns with the Ombudsman of a short delay and, concern with the service, are often having to wait in excess of 12 months for their complaint to be heard. In worst case scenarios, anything up to 2 years has been reported in some of the press. So it has led to increased scrutiny and criticism of the Legal Ombudsman's performance by some external stakeholders, which I think is an important element to the background of these latest scheme changes. Now, I don't think I'm saying anything controversial in highlighting that, because LeO itself has been very honest and forthright, particularly the new management structure there. It has recognised the need to address these widely publicised delays and backlogs at the front end of its process. It has committed to improve to an acceptable and sustainable level of performance, but by 2024. That gives us some sort of idea of the scale of the current problems, because at one stage the backlog was more than the Legal Ombudsman was actually closing and dealing with within a year. So these changes really do need to be seen as a central plank of the Ombudsman's overall plan to address these long-standing performance issues and to get up to an acceptable level of customer standards. Now, I discussed briefly earlier, that the sort of transition, it was relatively quick. It's worth noting with the existing Ombudsman rules that they were drafted under pressure sort of from consumer bodies with a deliberate intent to be relatively informal, to be based on the Ombudsman underlying principles of reasonableness. So they were not drafted at any stage by legal draftsmen. These were never intended to be sort of statutes. There was a strong belief when the Ombudsman scheme came first into inception that it would be a relatively informal scheme, that things would be dealt with different, quicker, shrewder. But this has left a number of issues for the scheme, which is really what this round of changes is seeking to address. So if you look at the changes as a whole, there are a number of minor technical changes to tidy up the rules. As a former Ombudsman, I see that they have now introduced a slip rule to correct any errors. Beforehand, that was a problem for Ombudsman. If you made a minor error, that was a clear minor error. If it had a material impact, it would have to be withdrawn and reissued. But there is now a slip rule to enable minor mistakes to be corrected. Reference to 2010 has been removed. That was there originally, but there's a general tidying up. But there are also a number of changes really designed overall to create greater proportionality in the scheme rules. The clear intent is to make the scheme more efficient, eradicate unnecessary delay. So the changes, whilst not huge, they do represent probably the most significant change to the scheme rules since the Legal Ombudsman first opened in October 2010, which probably explains why the rules are much needed and actually probably overdue. So I said the most significant change is probably to the time limits. This is the one you will have seen publicised. The time limits that were in place, in my view, always were never really appropriate for what was designed as an informal scheme to resolve complaints about poor service. You'll know that the existing time limits were that it had to be within 6 years of the act or omission, or within 3 years, if later than that, of the date when the complaint should have realised when there was cause for complaint. Now, these time limits, I think most of you will appreciate, are really sort of mirroring the negligence limitation time periods. Very legalistic, very long for what is basically a service complaint. I think this is a very welcome change here, that from the 1st of April, the time limits will be shortened significantly. So from the 1st of April 2023, the new limit will be 1 year from the date of the act or omission being complained about, or 1 year from the date when the complainant should have realised there was cause for complaint. Yeah, that can be later than the 1 year after the act or omission. It's important to note here that there is no change to the time limits that, the rule requires complainants to bring their complaint to LeO within 6 months of the date of the final complaint response. So ultimately, even though it's been shortened, there is still this shorter time period of 6 months from the final response that will still apply and hasn't changed. So the significance of the overall reduction from 6 and 3 to 1 and 1 might not be as significant as it seems at face value, because it's still 6 months from the date of the final response. But anybody who knows the scheme rules well will know that that 6 month time limit applies with a number of provisos that have to be met. Scheme rule 4.4a requires that proper signposting is placed on the final response, with a clear indication it is the final response, and the fact that the 6 months is going to run from the date of that letter. If the signposting and the details for the Ombudsman are not included, then the 6 months won't apply, and then the shortening of the time period will be quite important. Although there has been this change in terms of dramatically shortening, which I assume on the whole is good news for firms subject to complaints, it's worth noting that the discretion to accept out-of-time complaints has increased. The previous test under the rules, well, the rules as of today, which will be changing on Saturday, was that for a complaint to be accepted out of time, there had to be exceptional circumstances. Now, that bar was set quite high. I've seen people saying that they were suffering from illness, sending in doctor's certificates, but ultimately, unless there were really dramatic circumstances that meant that it was almost impossible, for the complaint to be submitted in time, that discretion was not generally exercised. So there really was a requirement for exceptional circumstances. The new rules do soften that. They will allow a wider discretion. LeO will exercise discretion to accept complaints under the new rules where they decide it is fair and reasonable to do so. So the barrier has been lowered there in terms of accepting complaints out of time. Now, what impact will this have on your firm in terms of your dealing with complaints? Well, there has been some communication from the Legal Ombudsman on some of the social media sites, which sets out that the decision as to whether a complaint is in time or out out of time is for the legal ombudsman. So the ombudsman's position is that you should not be declining to deal with a complaint under your own complaints procedure just on the basis it is out of time. Now, okay, I understand what they're saying, because ultimately there is a discretion there always for them to allow it to be accepted in time. If something is way out of time and clearly out of time, I think all firms will be entitled to take a view on that. The risk will sit with the firm if you decide that you actually are not going to deal with it. And my recommendation would always be that you do actually respond to the complaint, but you make the point that you believe it's out of time. If the ombudsman don't accept that, you know, it is at your risk. I mean, ultimately, if they decide it's in time and you haven't dealt with it, you have 8 weeks under your own internal complaints procedure to deal with a complaint, and there could be a case fee implication. So the risk would be on you if you were ever dealing with a complaint and deciding that it is out of time. Probably the most sensible or pragmatic approach would be to still deal with the complaint where it is possible to do so, but to make it clear in your response that you're doing so on the basis you still do consider it's out of time. So there is an obligation now to update your signposting. This is something that all firms will need to do. Very important, I would say, because the Ombudsman has said that it must be done from the 1st of April 2023. Now, I have this signposting in just to show that there was a requirement. I'm not sure how many of the people who've joined me today, their firms will have actually taken steps. There's quite a lot of firms I've seen who haven't actually taken any steps as yet. The Ombudsman was advising, you know, that these changes were flagged in advance, and were saying that as of now, you ought to have updated your signposting to tell people of the forthcoming changes and to flag them. So ultimately, up until tomorrow, you are required still to explain the existing 6 and 3 time limit, but to include this additional paragraph explaining that from the 1st of April, the time limits are changing and what they would then be, and also explaining that the 6 months from the final response will still remain the same. Now, if you haven't done so, I suspect very strongly, given that it's been guidance rather than there being a clear regulatory steer, that it was an absolute regulatory requirement. I think the risk of any adverse regulatory consequences are pretty low, really. I think the clear requirement and the fact that the Ombudsman says must is that you update all of your signposting in time for the change on Saturday. So certainly by Monday, I would strongly advise firms actually have it in place. Now, these changes to the signposting need to be across your across all of your information where signposting has been included and is now out of date. It needs to be in client care letters, final decision letters, you know, and the website information. So you do need to ensure that your complaints policy, including a version on the web, if it's published there also, is updated. If you use template complaint responses, do also make sure that those now are updated. It's very important that from the 1st of April, they have the correct information in there, along with the current complaints handling correspondence. Clearly, anybody who's got an ongoing complaint is somebody who is going to be impacted by it. So, you know, it's very important as the highest priority that those clients are informed of the changes, particularly given that, you know, the information that previously has been provided will now be out of date as of the 1st of April. So I've got on the slides here the recommended LeO signposting, which applies from the 1st of April, i.e. this Saturday. You'll see there that it mentions 8 weeks for the complaint. You should have the full details, including the the postcode and the telephone number. It should make reference to the fact that the complaint needs to be made within 6 months of you having received a final written response, and then it includes details of the new 1-year of the act or omission, or 1 year from the time they should have known about it or become aware of it. So ultimately, just to be clear on that, if somebody did become aware sort of 16 months down the line, it is, still, well, no, actually 16 months out of time, it's out of time anyway at that stage. But in theory, it's 1 year, whichever is the later. So it could be up to up to 2 years if somebody discovered almost after a year that if it was almost after a year when they could first realise that there was cause for complaint. So that is the changes to the time limits, and that actually covers off the changes to the signposting. Now, there has been a bit of an issue around whether or not firms should write out to existing clients. Clearly, existing clients may have been given information that as of Saturday will be out of date. The Law Society does recommend that firms do write out to existing clients and explain that the time limits have changed. In my view, that is very much the Rolls-Royce sort of most risk-averse approach. I don't think there is a clear regulatory steer that you have to write out, but it would be, given that there may have been information that is out of date, it's very important that it is updated. And if you're not intending to write out, what I would say is that it could be very useful to include a line in your footer of your letters and emails to ongoing clients to explain that the time limits have changed, and to perhaps to enclose a link to the new time limits. I think that is in accordance with the Legal Ombudsman's guidance that you tell clients where possible. It then brings their attention to the changes, as long as your information is then up to date and you are bringing your clients' attention to the changes as and when you communicate with them. For me, that is meeting minimum requirements and is likely to leave you fairly risk-free in terms of any adverse regulatory consequences. So moving on now to some of the changes and how these will affect the actual handling of the complaint by the Legal Ombudsman. Now, the first change, to date, it has always been a right under the scheme for either party who did not agree with the decision made earlier on to require a final decision by an ombudsman. So for people who don't understand the process, who've been fortunate enough not to have received many complaints and had an awful lot of dealings, the matter at the Legal Ombudsman is initially investigated by an investigator who, at the conclusion of their investigator, will issue what's called a case decision. That's not an ombudsman decision, but they will explain what view they have reached on the service, whether or not the service provided has been adequate or unreasonable, and where it's been unreasonable, they will set out what the recommended remedy is. Under the existing Legal Ombudsman rules, if both parties don't accept the decision at that stage, either party can then decide to have a final decision. And there is no obligation at that stage to require, setting out reasons. It's a complete reconsideration of the matter, looking at all the original evidence by the Ombudsman. When I was undertaking the role of the Ombudsman, it was quite it was quite strange on a number of occasions. I think a number of people who, perhaps came for a final decision and were a little bit disenchanted with the process would write in and say, well, I want a final decision, but I'm not bothering setting out any information because frankly, I've lost faith in it and everything else. And it was not unusual, as an ombudsman looking at it for the first time to actually come to a different decision to the investigator, even in the absence of substantial new representations or evidence. It is a completely independent review of the original decision. Where you do come to a new finding, it was a requirement to then issue a provisional decision because obviously both parties have to have the opportunity to comment on your different findings or different recommendations on remedy before you actually issue the final decision, as a matter of natural justice. But this is now going to be changed under the new rules. For the first time, the legal ombudsman will have a discretion to consider a complaint to have been resolved on the basis of the investigator's case decision if neither party provides any substantive reasons for disagreeing with that decision. So a simple disagreement now will no longer, be sufficient. It's important for firms to notice if they disagree with the investigator's decisions, it's important for them to set out why. If not, the matter can then be referred to an ombudsman who will have the discretion to make a decision to close the complaint as having been resolved by way of the investigator's findings. Now, this is a little bit curious for anybody who's a little bit of a complaints nerd like me. Having studied the Ombudsman's new drafted decision, it does strike me, well, what if a case decision recommends that a remedy is payable? Now, most of you will know that an Ombudsman's decision actually carries the same effect as if accepted by the complainant, carries the same weight as a court decision. But it has to be an Ombudsman's decision under the powers delegated by the Legal Services Act. It can't be a caseworker decision. So it is an interesting fact that although the Legal Ombudsman says it will then expect the service provider to honour the recommendation, if the service provider doesn't honour a recommendation that's been made for a remedy, when there hasn't been a final decision, ultimately there will still be that requirement for an ombudsman decision. So thinking about it, I'm kind of not so sure how significant this is going to be, because although clearly the advice to service providers would be to engage with the process, and if you're not happy with a case decision, to engage and set out why so that the ombudsman can consider it. If you didn't comply voluntarily with it, it would go to an ombudsman for a decision. And in theory, that would still be a completely independent reconsideration of all of the matters. It would have to be under the Act. It would not be recommended. I would have thought it would be far better for anybody dealing with a complaint who felt that a case decision was unfair to set out their reasons why. But it does strike me that that change is still not going to remove the need for an ombudsman's decision if there is not agreement from the service provider to actually honour any recommendation that's been made at case decision stage. Now, one of the more important changes to the scheme rules is in regards to the changes to Rule 5.7. Now, I've set out here a little bit more detail because I know some people who deal with the legal ombudsman and complaints won't have a detailed knowledge of all aspects of the scheme rules. The Rule 5.7 right to dismiss or discontinue a complaint, it's a discretionary power. So the rule does state that the ombudsman may but does not have to dismiss or discontinue all or part of a complaint if one of the following factors applies. Now, these are fairly wide, fairly vague, and give a fairly wide right for an ombudsman to decide that an investigation should not take place. This power is a preliminary power. It's certainly meant to be a preliminary power that is used at the outset of a potential investigation to decide whether an investigation is justified at all. So the existing power under 5.7a, for example, is that a complaint an investigation will not take place if, in the Ombudsman's opinion, there is no reasonable prospect of success, or it's frivolous or vexatious. That's been split up in the new rules. The no reasonable prospects of success still stands. Frivolous or vexatious is separated out, so it will still stand, but as a different rule. The current powers say if there's been no financial loss, distress, inconvenience, or other detriment, that has been changed, and we'll come on to that. It can be dismissed if there has already been fair and reasonable redress and the offer is still open for acceptance. So that's the importance of making a reasonable offer under your own complaints procedure. Then if the matter is not, if it's not accepted and it is escalated, there is the right to have the Ombudsman, request the Ombudsman to dismiss it. Running through quickly the other issues that currently exist in the rules, these are generally unchanged. So there's the previous complaint on the same issue. Unless there's new evidence, it can be dismissed on that basis. If a comparable independence, complaints or cost assessment scheme or a court has already dealt with the same issue, that's another ground for dismissal. Or if a comparable independent complaints or cost assessment scheme or court is going to deal with the same issue or is currently dealing with it, or under 57G, if it's more suitably dealt with by a court, arbitration, or another complaints or cost assessment scheme. If it's a discretion, and if the complaint relates to a discretion under a will or trust, that is grounds for dismissal because it's not a service complaint. Likewise, if the issue concerns a failure to consult a beneficiary before exercising a discretion under a will or trust when there's no legal obligation to consult the beneficiary, that can be dismissed. I think these are all matters that sometimes people don't pick up on and don't make the request. The issue involves someone else who has not complained and not appropriate to deal without their consent. That frequently, I explained earlier on that the scheme rules now do incorporate complaints by beneficiaries, but some of them can be dismissed on occasions when there is a lay executor involved. If the complaint is one that is better off dealt with by the executor, and 5.7J is sometimes a ground that can be used in those circumstances. You do, because the dates for making a complaint run from the date of knowledge, where that date of knowledge is many years after the original event, you can seek dismissal under 5.7K, not practical to investigate the issues fairly because of the time which has elapsed. Sometimes, complaints relate to work that's been carried out by a firm via an overseas lawyer. You can seek a dismissal if it's outside England and Wales and there's insufficient connection with England and Wales. Or if the complaint is under M is a refusal to provide a service and there's no evidence the refusal was for other than legitimate or reasonable reasons. Now, interestingly enough as well, the existing rules do have this catch-all clause under 5.7N that a complaint can be dismissed and there can be a decision not to investigating it if there are other compelling reasons why it's inappropriate for the issue to be dealt with by the legal ombudsman. That catch-all has been used in a number of different scenarios, particularly where a complainant has accepted an offer that's been made under a firm's own complaints procedure, but then has subsequently decided to escalate it anyway. Generally speaking, the ombudsman takes the view that they shouldn't be taking and that having their cake and eating it and then seeing if they can get a better offer. So they would normally have dismissed it under 5.7N. But that, it was that catch-all that was used to deal with that scenario under the existing rules. So these powers have been extended under the new rules. All of the existing powers exist, but actually they have been extended. The most important extension, I would say, is to Rule 5.7B. You'll recall that the existing power was, the right to dismiss the complaint if there was no detriment at all suffered. Now, it's quite difficult to actually establish that because given that distress and inconvenience is a detriment that the ombudsman can remedy in some circumstances, it's very difficult where there has been a technical sort of issue of unreasonable service to show that that person hasn't been upset by it. The new rule is going to raise the bar on that. It is going to say that a complaint can be dismissed if the complainant has not suffered significant loss, distress, inconvenience, or detriment. So that is potentially a significant change. It is going to mean that in minor sort of service issues, it is always worth considering whether or not the detriment is significant. If it's a technical breach, that may bring more complaints within the scope of 5.7b, and it's something for firms to consider if a complaint is escalated. Now, one of the more interesting changes is this new rule 5.7p. I did give the background, and I did explain, at the outset here that the object of these changes is really to try to increase efficiency. We do have this new ground being introduced here under a new rule 5.7p, that a complaint can be dismissed if it's considered not a proportionate use of the Ombudsman's time to investigate the complaint due to the likely impact, complexity, the amount of evidence provided, or due to the conduct of the complainant during the investigation. Now, this is, the drafting of this new rule is a little bit interesting in my view. It's a little bit of a catch-all. There's several different elements in there, isn't there? If you look at it clearly, I mean, the conduct of the complainant can. The Ombudsman has explained in some of the correspondence around this that they're not expecting this to be very widely used. I mean, on the face of it, it could deal with a lot of complaints, which bear in mind, though, that the existing rules already gave the power to dismiss complaints if, for example, there were complex issues of fact and law. They could already be dismissed on the basis they would be better off dealt with by a court. This seems to be a new rule that is going to deal with the case, I suppose, that complainant who will never give up, the person who is sending in reams and reams of additional information. Many firms will have come across somebody like this occasionally. I think if you ever consider the most difficult complainant that your firm has ever dealt with, and then imagine that times across the whole country, all of these people do end up at the Legal Ombudsman's office. And in terms of the efficiency of the scheme, some of them can create files that are several volumes wide by the end. And for a scheme that has, sort of limited resources to deal with complaints across England and Wales, a number of complainants like that can take a disproportionate use of the Ombudsman. This is what this extension to the Rule 5.7 powers is intending to address. It's intending to give the power for somebody who is so persistent that they are raising issues that is going to take a disproportionate level of resource and time, such that it's not going to be proportionate. That will actually be a ground. The exact interpretation will become clearer. It's a new power. The wording does suggest it's quite wide, but as I say, the communications from the Legal Ombudsman now would suggest that power perhaps isn't going to be as often or widely used as the wording may suggest. I would think the extensions to 5.7b are likely to be more significant and to provide more opportunities for challenge to firm. One of the other changes is this new rule 5.7q. So you can dismiss a complaint due to an undue delay in bringing it. This is really, I think, specifically to address an issue that the Legal Ombudsman has had with some complainants where the issues have changed throughout the course of the investigation. There have been instances where the complainant has wanted to raise additional issues almost throughout the course of the investigation, and there have been concerns from service providers, on the receiving end of that the goalposts are constantly moving. Now, under 5.7q, if additional issues are brought in later in the process, which could have reasonably been brought in at the outset, the Ombudsman will have a discretion to dismiss those complaints on the basis they've been raised too late. They should have been raised at the outset. The intent there is clearly that all issues are set unless there's a good reason not to, and that there is one investigation of the entire service complaint, rather than in the past where there's been on occasion several different complaints raised by the same person in relation to the same retainer. The change to discretion to dismiss a complaint where the service provider has made a reasonable offer, you'll see that has now been extended to include offers which have been made and accepted by the complainant prior to referring the complaint to LeO. As I said, that was previously dealt with under the catch-all 5.7n power anyway, but it does put the Legal Ombudsman on slightly further, clearer ground. So we discussed the further steps here, that the guidance on whether to write out about changes has been a little bit vague. There's no actual requirement to do so, I would say, but it perhaps is the Rolls-Royce option. I do recommend that actually you bring this to the attention of existing clients. I would suggest, as there is no recommended wording, you could either just put in a very simple, please note that from the 1st of April 2023, the Legal Ombudsman's time limits for accepting complaints have changed, and insert a link to your updated guidance on your website when that has been updated. Option 2 is just setting out the entire changes in a little bit more detail. You'll know whether your footers have room for that. Obviously, that sets out the whole thing without requiring them to access your website. Now the other change that I did want to highlight today before we come on to the questions and answers, a lot of the publicity has from the Legal Ombudsman has stated that this is a minor change to the rules. Now, I personally don't agree with that. I think this is actually quite a significant change, and it's quite an important one. For those of you who aren't familiar with Rule 5.4, who don't know all the idiosyncrasies of the current scheme rules, Rule 5.4 is an important right for service providers and authorised persons because it gives them the right to challenge an investigation. A service provider can challenge an investigation and say that a complaint shouldn't be considered by the Legal Ombudsman, shouldn't be investigated on the basis it's not covered by the Legal Ombudsman under Chapter 2. So that means it's out of jurisdiction. It's not a service complaint that is actually covered by the scheme rules. It gives them the right to challenge that actually it shouldn't have been accepted in the first place because it's out of time, according to the timescale set out in Chapter 4. Difficult one to use if it's been accepted as an ombudsman's discretion, but if it's outside of the 6-month time limit and you can show that that the final letter was given and when it was accessed is outside the 6 months, that's an area that can be, sort of quite successful if you have the factual evidence. And the third right is this right now to seek to have it dismissed under Rule 5.7. Now 5.7 has been extended, so the right of service providers to argue and challenge an investigation on the basis that it should be dismissed under Rule 5.7, in my view, becomes more important. But the change here, previously an authorised person could raise such a challenge at any stage of the process. These changes are all about efficiency. They're all about addressing what has been, a substantial backlog that has been building up. In some cases, multiple challenges have been raised, sometimes at extremely advanced stages of the investigation. In some cases that I dealt with, when a matter came to me for a final decision on a matter, it was clear that in the response to the case decision, there was actually a 5.4 challenge there, which required a decision by a separate ombudsman. I mean, clearly that was a little bit ludicrous. It was creating a lot of time because there was a requirement to write out to both parties, take representations, put the substantive investigation on hold, and then get a decision on whether or not the 5.4 challenge should be upheld before the investigation could be resumed. Now, clearly that wasn't really in either party's interest for that to happen multiple times. I'd say the power of under 5.4 is always intended as a preliminary application. The idea that somebody is arguing that there shouldn't be an investigation when the investigation's already actually taken place and been completed is far too late in the process. So the right to raise it at any time is now being removed. The new rule now states the authorised person should provide reasons for the challenge at the earliest possible opportunity. Now, it doesn't define this. It also, I notice, if you look at the drafting of the new rules, which are currently on the Legal Ombudsman's website, although the rule tends to imply that if there is not a challenge, the Legal Ombudsman will decline to actually look at the challenge and make a decision on it. It won't be accepted. That actually isn't explicitly stated, so that seems to be a little bit loose in the drafting. It's certainly sensible, though, for service providers now, given that this could be a potentially more useful tool in resisting complaints, given that the shortening of the time periods for raising complaints and also the extended powers in Rule 5.7, that service providers are aware that there is now the need to challenge at the earliest possible opportunity, and the potential that the right, there is a risk there, depending on the interpretation adopted, that right to challenge will be lost if the Legal Ombudsman deems it wasn't done at the earliest possible opportunity. Again, I think this is something that is designed to make things quicker. It is eminently sensible, and I don't doubt the sort of wisdom of it, but it is something that service providers should be aware, and I wouldn't agree that it's a minor change. I think it is important and something that service providers need to be aware of. I'd also flag anybody on the call today who has anything with the Legal Ombudsman and is considering whether or not a challenge is possible. Well, tomorrow is actually the last day you can do that without having to prove that you've done so at the earliest possible opportunity. So if you have any cases pending with the Legal Ombudsman where you think a challenge is necessary, although we don't know what they will interpret the earliest possible opportunity to be, you may wish to get it in tomorrow. It doesn't take very long to actually put the request in that an ombudsman reviews whether or not it should be dismissed or whether it's out of time. So that is my gallop through the changes. We have, I think, about 5 or 6 minutes left for any questions. So, Sam, are there any questions?
Yes, we do have a couple of questions. Before I move on to them, I just wanted to mention that we have noticed a lot of you have had technical issues, so we will distribute details tomorrow on how to view the recording and the slides to everyone who is registered. Just then you can see it all again. So if I just hit you with the first question. We've got the model text from LeO explaining how to escalate to them, makes no mention alternative to complaint bodies and the European directive. Does this mean we no longer need to include that information?
That is a very good point. To my knowledge, the requirement is actually under European law. It's under the directive, and that still stands. Now, this one really has never fitted in very well. The requirement is to explain the requirement of an alternative dispute resolution, that could deal with it, and to explain whether or not you could actually, whether you're prepared to deal with it. Most service providers, we would advise to include a line to that effect to ensure that they are in compliance with the necessary directive. It is a little bit pointless, in all honesty. It's one of those things that doesn't add a lot of value, because most service providers would simply confirm that they would not be willing to use the services of an ADR instead of or as well as the Legal Ombudsman, so they would use the Legal Ombudsman instead. And that, as far as we are aware, is compliant with the requirement. But in terms of your question, do these changes mean that it is no longer applicable? No, these changes actually don't affect that requirement insofar as it existed. It was a bit of an anomaly anyway, I think, because it didn't really work with the Legal Ombudsman. But any obligation that did exist, and I think there is some legitimate debate around that, still exists. It's not affected by these changes.
Brilliant, thank you for the answer to that one. I believe you covered this one, but in case you want to add another note on it, Is there any notification that needs to be made to existing clients?
I think I have covered that to some extent, but just to say, I mean, the guidance on that has been a little bit vague. You know, there have been inconsistent guidance notes on that issued by different parties. It's quite difficult for you know, compliance consultants like DG Legal and ourselves to give a definitive answer when the steer from the regulators has not been as clear cut. My view, as I think I set out, is that actually writing out would be probably disproportionate, albeit it would be, you know, the absolute best customer service, because the information that previously has been given on signposting is now out of date. The Legal Ombudsman in their original guidance stated you should tell existing clients where possible. Now, that is why I've set out in there, you know, the suggestion that you might, if you're not going to write out, which clearly is the Rolls-Royce answer, but it is a little bit sort of expensive and time consuming, you know, so you will take a view on that according to your own risk threshold. If you decide not to write out, I would recommend that you consider instead putting in a footer in your letters and your emails to existing clients, because I think that would leave you fairly fireproof in terms of saying you've taken steps and let clients know where reasonably possible to do so.
Brilliant, thank you for that. So this question is quite popular. If the 6 months from the date of the final complaint response takes us over the 1 year period to refer a complaint to the LeO, will they still be able to refer? So effectively, they could then have 18 months to refer a complaint.
Right. The short answer to that is well, actually, it's not a short answer to that. The interim arrangements here are not clear. The guidance on this has been extremely vague. So in the intervening period, it is not clear from the guidance whether or not the Legal Ombudsman would accept a complaint from anybody who has been signposted to the internal complaints procedure and the 8 weeks is still running. You know, if they had actually raised it to you, say, 18 months after the issue, and in accordance with the signposting they would have been given, and they then refer it to Legal Ombudsman after the time changes have changed, I suspect, given the reason, you know, where it's reasonable to do so, they can exercise a discretion, that the Legal Ombudsman would still exercise its discretion. Moving forwards beyond the interim sort of arrangements, the transitional arrangements, I'm trying to think. The question is, if the 6 months exceeds beyond the 12 months. Well, no, it's it would need to be within both of those things. So ultimately, it has to be within the year of knowledge or the year of finding out that you had cause for complaint. If the I'm trying to think, that's an interesting question. So you're saying if they raised it with you, say 2 weeks before the 1 year elapsed, and then you said they got 6 months to do it, I would say the requirement under Chapter 4 of the scheme rules is that both aspects of that are met. So I would say that if it's outside of the 1 year and the 1 year, but still within the 6 months, it's actually out of time. But what I would say to firms is you don't have to worry about that to some extent, because ultimately it is for the Legal Ombudsman to make that decision. So their clear guidance is that you should not be declining to deal with a complaint under your own complaints procedure on the basis you think that it will be out of time. The Ombudsman in any event has a discretion that they choose to exercise in more cases now, and ultimately how they interpret these specific you know, sort of idiosyncrasies of the two separate time limits running side by side will become clearer over time. At this stage, you need to deal with the complaint under your own procedure, and then obviously wait and see, I suppose, if the Legal Ombudsman decides it's in time. It may still exercise its discretion to investigate. If not, there is potentially a bonus that they may decide it's out of time. But you know, the stance that the Legal Ombudsman will adopt hasn't been entirely clear from the guidance they've issued. So it really is a case of wait and see on that.
Thank you. So the next question we've got is, the guidance is unclear if changes need to be communicated to clients of closed matters. If you have updated all the signposting, so new clients are sorted, do you have to separately notify existing clients individually? I feel like we've done
So I think there's two slightly separate issues in there, isn't there? I think the original one was, do you have to advise closed? Now the guidance hasn't been clear cut on that, so I flag up that ultimately all firms need to take their own risk-based view. I can only express my view that if I ran a law firm, I certainly would not be contacting any closed firms. I'd be making sure my signposting was up to date. The Legal Ombudsman's guidance was to inform clients where possible. In my view, it's not possible or proportionate or reasonable to expect you to go back to every client in the history that that you've ever given the previous signposting to. So my answer on that would be no. There hasn't been clear guidance or steer on it, but I think it makes sense given the interpretation on the other thing. My view is, I suppose a little bit more risk-based. I would not actually recommend writing out to all clients, but some perfectly reputable, sort of people would say it's better to do that. And the Law Society's advice is probably that you ought to write out to people to correct some information if it's out of date. But my view is for current clients, you should consider putting in a footer. You definitely need to make sure that your signposting is up to date from Saturday. I would not be recommending that any closed files are, are notified.
Brilliant. So if the Ombudsman's decisions are final and there is no appeal, what are the key determinants of applying to the High Court to challenge an Ombudsman decision because it is legally flawed, such as a judicial review?
Well, judicial review really is the only option at that stage. And ultimately, simple disagreement with facts is not a basis for, for judicial review. It would need to be, fundamentally flawed. That would be getting into the realms of legal advice, so ultimately if there are grounds, but all of the normal grounds for potentially challenging do apply. So for example, if a decision is made by somebody who doesn't have the authority to make it and it's ultra vires, if the decision is ultimately completely unreasonable to the extent it's almost Wednesbury unreasonable, that potentially is grounds for a judicial review. But ultimately, the normal principles of judicial review apply. It's not whether the decision is right or wrong. The court will generally allow a fairly wide discretion for the Ombudsman. The Ombudsman used to get a lot of challenge when I was undertaking the role on the basis, well, that's a negligence issue and a court would decide something different. Well, the scheme rules actually afford the Ombudsman quite a wide discretion to decide what is fair and reasonable, in their own opinion. So challenging, judicial review is not easy. There have been one or two cases that have been successful, but they are rare. It's something that, consider very carefully and seek your own counsel if you were ever minded to do that. But the grounds of challenge are quite limited.
Thank you. So can you confirm that we will be compliant with the SRA Code of Conduct Rule 8.3 on complaints handling information if we do not notify existing clients of changes on or before the 1st of April?
On or before? I would say arguably on the, it ought to be, you ought to be people technically on the 1st of April. I can't imagine that there would be any consequences for anybody who updated the information on Monday, given that it's a non-working day. But actually the requirement, I would say, is to actually ensure that the signposting is up to date. The SRA has provided less guidance on this than the Legal Ombudsman. There was nothing with it really. Most of the SRA's guidance has been to refer to the changes, and to refer to the Legal Ombudsman guidance. My view on that is that it's extremely unlikely the SRA would be taking any action against anybody for not doing that. But you would, where the guidance is as vague as it has been, ultimately firms have to decide their own risk threshold on it. You know, my recommendation would be that the likelihood of any adverse regulatory consequences for not specifically noting individual clients of the matter, particularly if you were following the recommendation to include a footer on all ongoing communications, and you have updated your signposting on all of your literature from the date the changes came in, the likelihood of any adverse regulatory consequences are minimal, you know, really, really small.
Okay, moving on. Do you raise the Rule 5.4 challenge or seek dismissal under Rule 5.7 simply by writing to the LeO, or is there a more formal process?
It's as informal as that. You simply write to the Legal Ombudsman, you explain you want to raise a challenge. You don't even have to quote Rule 5.4, but ultimately, I mean, I would just sort of say I'm raising it under, say, 5.4c, and it is a challenge that it should be dismissed under 5.7, and I would quote the rules and I would set out my grounds. But any informal letter enables that challenge to be raised.
So in your opinion, do you think it's about time to consider the implementation of stronger rules on how clients are informed about their rights to complain and to ensure that verbal expressions of dissatisfaction are treated as complaints? Do you want to add your comments on that?
It's one of these difficult. I mean, I think people who are complying with the rules are already probably doing what they can. I mean, most firms are now informing, and the requirement is to inform clients of the full information at the outset. Firms have generally got it on their website, and if they want to take advantage of the shorter time scale, they are putting the information in the final letter. It is a requirement of conduct that, you know, that proper information is given in the client care information. Should it be stricter than that? Was that the question, Sam? It's one of those
in
things.
Your opinion, yeah.
I mean, in my opinion, it's, you know, I would say the rules themselves, if complied with, are actually adequate. But whether or not stricter enforcement measures need to, because the issue is clearly with, you know, with firms who don't comply with the rules as they currently stand. I think the rules themselves are probably adequate. Whether enforcement is, or whether any wider publicity, you know, is needed for the Legal Ombudsman so that clients are aware, is possibly a good point. Although, given the extent of the delays, I suppose a cynic would say, well, obviously enough people are finding their way to the Legal Ombudsman. It's currently outstripping the ability of the Legal Ombudsman to deal with the complaints. But you know, I do agree that the information should be circulated as widely as possible, so consumers do have, you know, knowledge of their right to escalate, and the rules do require that. Not quite sure how, you know, I suppose you could increase the sanctions or the enforcement for firms who are not doing it, but you know, if they are complying with the rules, then clients ought to be made aware.
Brilliant. Thank you for that. We've had a question by email. So a client's file was closed 4 years ago. The client was advised of old timescales for complaints of 6 years. They complained on the 10th of April 2023. Are they out of time, or will LeO deal with this? I think that's...
Sorry, they were... sorry, Sam, could you just say that again a little bit slower? So the timescales were what? They dealt with it?
So it was closed 4 years ago, and the client was advised of the old timescales for complaints, so 6 years. They complain on the 10th of April 2023. Are they out of time, or will LeO deal with this?
Well, Legal Ombudsman will always make their own decision as to whether or not they can accept it. But actually, you know, on the old timescales, if it's within 6 years of the act or admission, then technically it is in time. And so it would depend whether proper signposting was given to satisfy the requirements in Scheme Rule 4.A, in which case, you know, the 6-month time limit set out in 4.4b would apply. And clearly, so if there was a final response properly signposted and it's been raised, it would be outside of the 6 months. But if it's within the 6 years, then ultimately it would be in time. As of Monday, it actually, well, you know, if it's been raised, the clock stopped ticking. I mean, as of Monday, that obviously wouldn't be out of time. whether or not the Ombudsman would exercise its discretion. Say that complaint had been raised on Monday and it was within the original signposting but outside of the new timescales, is an issue that really only the Legal Ombudsman could answer, because it would depend whether or not the Legal Ombudsman in those circumstances decides it's fair and reasonable to accept it out of time. It would be out of time of the new timescale at then, but it's not out of time as of today or at the date it was raised, if it was raised on the 6th of April, 10th of April. So.
So next question is, do you know if there's any intention from the FOS to align their time limit rules with the Legal Ombudsman?
I don't know off the top of my head. I mean, ultimately, the FOS and the Legal Ombudsman are run by completely separate boards. There is no oversight body that would naturally coordinate any changes of this sort, and frequently Ombudsman services have their own individual timescales that they decide are fair. So my assumption is no, but I don't actually know. I haven't looked at any information on the Financial Ombudsman Service on their timescales.
So this one's about charges. So the LeO charges a fee if they investigate. Is there a right or any provisions to challenge their fee? Do you know anything about that?
Yes, there is a right to a case fee waiver. So ultimately, to be eligible for a case fee waiver, the matter needs to have been determined in your favour. So that is that it has either been withdrawn, or no finding has been made, or that actually any offer you made under your first tier was not exceeded. Secondly, to actually be eligible for a case fee waiver, you need to show that you've taken all reasonable steps to deal with the complaint under your own complaints procedure. Now, this is an area which sometimes can be controversial, because clearly firms have 8 weeks to deal with their complaints, but they will not be deemed to have taken all reasonable steps if they've included additional timescales and communicated those to the clients, and then they don't comply with them. So, for example, if they say there's a first tier of our complaints and we'll respond to you within 2 weeks, we'll invite you to a meeting within a week, and actually then they get a final response in 8 weeks, that would be considered not to be taking all reasonable steps. But if you had a very, very simplified complaints procedure and just said, we are going to provide a response within 8 weeks, we will acknowledge it within a couple of days and then provide a response in 8 weeks, there's nothing to stop you then actually, carrying out a process and dealing with it far better and beating, the timescales you set. But just providing the response within 8 weeks, if you haven't made any additional commitments, will satisfy, taking all reasonable steps, as long as you've dealt with the complaint properly, you've identified the issues and come up with a reasonable response, and you've satisfied the other limit of the test in that you've actually come away with a satisfactory conclusion. Now, technically, if you're ever, if a complaint is withdrawn, the Legal Ombudsman could still have a look to decide whether you've taken all reasonable steps. But a number of clients that I've advised, I say to them, if it has gone to the Legal Ombudsman, it is worth reopening negotiations with the client if you feel that you haven't put an offer forward that the Legal Ombudsman would consider as reasonable. Because if it is withdrawn, in my experience, the Legal Ombudsman has never gone after a firm for a case fee, because they simply don't have enough information to make the decision that you haven't taken all reasonable steps. So my advice is always to see whether or not it can be resolved on the basis that the client withdraws the complaint.
Brilliant, thank you. So I think we have time for one more question. So this person's asked if it's sufficient to include a link to the Ombudsman website rather than setting out the time limit. So do you believe that's enough?
No, I don't. I think it's quite important, actually, that for 4.4a, it used to be extremely strict that the whole amount of detail had to be within the actual closing letter itself. It had to be a standalone. The stance, I understand, in terms of interpretation has softened slightly. So, for example, if you enclosed your complaints procedure and you made reference to the information being, in section 4 of the complaints procedure enclosed, as long as it was enclosed, they would count 4.4a. I don't think a link to your website is going to be sufficient. And I don't think the fact that it was in literature earlier in the process is sufficient. My advice here is err on the side of caution and make sure that the information is set out in full. Therefore, the 6-month time limit will apply. I would set it out in full in the body of the letter and not take any chances.
Brilliant, thank you. Okay, well, thank you very much for presenting and answering all those questions. And thank you everyone for joining us. So as a reminder, a slide and a recording of the webinar will be sent over tomorrow. This afternoon, you should receive an email asking to rate us out of 5 stars. So if you've enjoyed today, please do leave us some feedback and any suggestions you have for future topics. Our series of webinars will continue on the 11th of April, where Haresh Sood will be presenting a webinar on copyright in films and beyond. Thank you very much for watching and have a good afternoon. Thank you, Paul.
Thank you.